You're asleep in your own bed when glass explodes into your room. You believe it's a home invasion, so you reach for your legally owned firearm to defend yourself. But then, you hear the word police, and suddenly, you're the one facing attempted murder charges. Sound unbelievable? It should be. Yet this scenario plays out far too often. I'm Jeff Hampton, the people's lawyer. In this video, I'm exposing first how law enforcement routinely shifts blame for their own errors onto you. Second, the tactics they employ to make this stick. And third, the precise language from a landmark Supreme Court decision you can use to hold them accountable. Because when police make a critical error, they possess the means, the methods, and the power to rewrite the story. And in their version, who plays the antagonist? You. So stay until the end, because I'll show you how to redirect responsibility squarely onto those who created the danger, the police. But first, we need to examine the most perilous development in modern law enforcement: officer-created jeopardy. This is when an officer, through their own actions, manufactures a high-risk, volatile situation, then uses the very chaos they cause to justify using force against a citizen. Let me illustrate with two real cases. 2016, Ashton Barnes. Barnes is stopped by Deputy Constable Roberto Felix for a minor toll violation. Seems routine, but it spirals when Barnes attempts to drive away. Here's the crucial detail: Barnes was unarmed. Deputy Felix then jumps onto the moving vehicle, draws his weapon, and fires down at the unarmed driver. Audio clip, shots fired. Deputy Felix's defense? He feared for his life because he was on a moving car. But wait, he chose to jump onto it. He authored the peril. If that's not enough, consider Diamond Ford, Florida, 2020. Diamond is asleep. Police execute a no-knock warrant at the wrong house. Windows shatter. She hears yelling and chaos, but no identification from the officers. Like anyone would, she grabs her firearm, believing it's a break-in, and fires once, injuring an officer. The police response? Charge her with attempted murder. She only avoided conviction because her 911 call, made during the incident, proved she genuinely believed it was a home invasion. That recording was her lifeline. Then there's the 2020 case of Army Lieutenant Karen Nazario. He was pulled over in Virginia for a supposedly missing license plate, though his temporary tag was clearly displayed. He did everything by the book, slowed down, activated his hazards, and proceeded to a well-lit gas station. Two officers approached with guns drawn, screaming for him to exit. When Nazario calmly stated, "I'm honestly afraid to get out," an officer replied, "Yeah, you should be." They pepper-sprayed him, dragged him out, and accused him of resisting. Nazario did everything right. Hands visible, compliant, recording. His lawsuit sparked a national debate on police power, resulting in one officer's termination and a jury confirming his rights were violated. The lesson? Doing everything right doesn't always prevent bad policing, but documenting everything can stop the blame from sticking. Barnes, Ford, and Nazario were all placed in jeopardy by police actions. In each case, officers attempted to blame them for the outcomes. This leads to the critical standard for judging these situations. Until recently, courts applied the moment of threat rule, focusing only on the split second when force was used. They asked, was the officer in danger at that exact instant? This was like judging an entire movie by its final 3 seconds. Thankfully, in 2025, the U.S. Supreme Court changed this in Barnes v. Felix, the very case we just discussed. The court ruled that context must be considered. Justice Elena Kagan wrote, "To determine reasonableness, courts must consider all relevant circumstances, including events leading up to the use of force." Now, 3 questions must be asked. Did the officer unnecessarily escalate the situation? Did the officer's actions increase the risk of a violent outcome? Did the officer ignore safer alternatives? If the answer is yes to any, the use of force can be deemed unreasonable, even if the officer claims fear in that final moment. This is a powerful legal tool, but let's be practical. In a violent, unfolding mistake, you can't wait years for the courts. You need to survive and prevent the officer from flipping the narrative. Here's how. Step 1. Maintain composure and communicate. This is difficult but vital. Do not match an officer's aggression. Appearing threatening gives them legal cover to escalate. Don't argue, run, or make sudden moves. Instead, narrate your actions. Officer, my ID is in my back pocket. I'm going to reach for it slowly with my right hand. Keep hands visible. Move deliberately. Avoid any furtive movements they could use as a pretext. Ask for clarification if orders conflict. If told to keep hands on the wheel and get your ID, say, "Officer, I want to comply. Do you want my hand to remain on the wheel, or should I reach for my ID?" Step 2. Record everything. Your camera is your best witness. Start immediately and state calmly, "For my safety, I am recording this interaction." Use your phone, dash cam, smartwatch. Even audio alone is crucial. At home, ensure security or Ring camera footage is saved to the cloud. This evidence is often the sole factor between your word and an officer's rewritten report. Consider Ebony, Washington, Florida, 2022. This pregnant mother was pulled over. She turned on her hazards and drove to a well-lit area for her children's safety. The deputy rushed her car, yelling, "Pull over or I'll put you into the ground," and demanded an apology for her noncompliance. Her recording of this textbook safe behavior led to his resignation. Or Tyrone Pfeiffer, 2021. This 68-year-old grandfather was mistaken for a suspect by NYPD, assaulted, and then charged to cover up the error. Only body camera footage cleared him, leading to a $5 million lawsuit. The lesson? When police double down, your recording becomes even more critical. Step 3. Use the magic words to preserve your rights. Against searches, "Officer, I do not consent to any search." This preserves your Fourth Amendment rights. They cannot legally punish you for this refusal. Against self-incrimination, "Officer, I am exercising my right to remain silent. I will not answer questions without my attorney present." Then stop speaking. If manhandled, calmly narrate, "Officer, I am not resisting. I am not moving." This fights false resisting arrest charges. Step 4. Special protocol for legal gun owners. If you are carrying and an officer becomes aggressive, use extreme caution. State clearly, "Officer, I am a legal permit holder. My firearm is located, state exact location. How would you like me to proceed?" Then follow instructions exactly. Never reach, never surprise them. Assume nothing. Step 5. Meticulously document afterwards. Photograph all injuries immediately. Seek medical attention to create an official record. Write a detailed account with times, dates, names, badge numbers, and quotes. Preserve video in multiple locations, cloud, hard drive. Consult a civil rights attorney immediately. Ruby Johnson, Denver, 2022, exemplifies this. Police raided her home based on a faulty iPhone tracker. The 78-year-old documented everything, sued, and won a $3.76 million jury award in 2024. How to fight back systematically. File a formal complaint to start a paper trail. Consider a Section 1983 federal civil rights lawsuit for constitutional violations. Leverage the Barnes versus Felix ruling with your attorney to challenge the continue.